Deja vu all over again. Welcome back. I am your host, Dave, an almost 10-year intellectual property attorney. And today we are going to be talking about the Babe and 8 Nike lawsuit. Now, for those of you who may have been following this or may not have been following this, Nike and Babe and 8, they recently settled uh, on the trademark lawsuit that Nike brought against Babe and 8, which is a Japanese shoe manufacturer. And I guess they kind of make apparel and other things as well, not just shoes. But Nike sued them in regard to their Babe and 8 shoe that looked similar to the Nike Air Force Ones. And that settlement agreement had been reached at the end of April. It was just announced by Babe and 8 that they're going to be releasing a new shoe. And I want to hear from you guys. Leave your comments in the comment section. Do you think that this shoe is similar still to the Nike Air Force Ones? I want you to let me know whether or not you think that Nike is going to bring another lawsuit against Babe and 8. Like I said, this shoe is still similar, so it'll be interesting to see what happens. We're going to go through this article from Complex, so shout out to them, and then we are going to go look at the IG page of Babe and 8 and kind of check out the shoe. We're going to see some comments and see what other people are thinking about the shoe and whether or not it's still similar or not similar to the Nike Air Force One. So you may be thinking, hey, how are they able to protect the Air Force One shoe? So we all know that Nike has a trademark on the Nike shoe symbol as well as the actual word Nike. However, Nike also has what is called a trade dress protection, which is the physical appearance of some of their shoes, some of their more popular shoes, such as the Jordans, such as the Nike Air Force Ones. And regardless of what symbol or logo is associated with the shoe, that allows for Nike to still bring a trademark infringement lawsuit against the alleged infringer if they are selling a shoe that's essentially the same as what Nike has in the Air Force Ones or the Jordans. So, but it's a few, I guess, prongs or elements that have to be satisfied for you to even get trademark or trade dress protection on a shoe. And trade dress protection is very powerful because it lasts as long as you are selling a shoe. And essentially, it can last forever. Where we know that patents, they last 20 years if it's a utility patent. If it's a design patent, it only lasts 15 years. We know that copyrights last the life of the author plus 75 years or 70 years. I forget all right offhand. But we know trademark and thereby trade dress protection lasts forever as long as you're using it, as long as you're essentially selling the shoes or using it as a brand identifier. So it can be a very powerful tool, but it's 4 things that you need in order to be able to claim trade dress protection on your product. Number 1, it has to serve as a source identifier. In other words, when people look at that shoe, they need to think of that company. So when you look at the Air Force Ones, you automatically think, oh, that's a Nike shoe. When you look at the Jordan Ones, you automatically think that's a Nike shoe. Regardless if the actual logo Nike or the word Nike is associated with the shoe, the actual shoe itself, the look, the physical appearance of the shoe lets you know whose shoe that is. So that's the prong 1. Prong 2 is it has to be distinctive in a marketplace. Again, when you look at that shoe, you know it's associated with Nike or whatever company that you're looking at that actual product that has trade dress protection, you know what company is associated with. So number 1, again, the actual the trade dress, the product has to be used from a branding standpoint. It can't be just one of the many other products in that the company is selling. You have to actually, you're using that actual product as a brand identifier, as a source identifier. And then number 2, it has to be distinctive in a marketplace. When people see that, when a consumer sees that, they know what company that product belongs to. That's prong 2. Prong 3, it has to be used in commerce. So we all know that, again, with patents, you can actually get a patent, whether it's a design patent and a utility patent, and just sit on it. You can't do that with trademarks. You actually have to be using it in the marketplace. You have to be selling it. We call that use in commerce, which makes sense, right? If you're going to protect this thing forever, potentially, you actually need to be using it. You just can't, like you can do with domain names, get a lot of them and just sit on them. You can't do that with trademarks. You have to be actually using it in commerce. And the last thing, it cannot be a functional item. It has to be a non-functional item. What does that mean? Well, if different elements that your protection are important for the use of the shoe, so you can't protect a tongue of the shoe, you can't protect the lower the heel of the shoe, because those are important features. You can't protect, just generally speaking, the sole of the shoe, because that's important for a shoe, and it has utility or functional use. But all the non-functional elements, the lines, the stitchings, things like that, that have become distinctive and used as a source identifier, you can protect those. So those are the 4 elements that, again, you need to prove and show to be able to get trade dress protection. I'll share them again. That's the product, the trade dress, the actual physical appearance has to serve as a source identifier. It has to be distinctive in the marketplace, saying that, hey, the consumers, when they see that, they know it's associated with that particular company. In this case, when you look at the Air Force Ones, you know that's a Nike shoe, regardless if the word Nike or the swoosh logo is on it. Number 3, it has to be used in commerce. You actually have to be selling it. And then number 4, the primary, it must be the actual appearance that you're trying to protect has to be non-functional. It cannot be some type of functional or have uses. So those are the 4 things. So let's pull up this complex article. We're going to read through it. And I want you to let me know in the comments section on whether or not you think that Baby Nape is likely to get sued again. And then we're going to look at the IG page of Baby Nape and some of the comments under the shoe. So this is Nike settles the Baby Nape lawsuit. And again, this is from late April. If you see here to the right, late April of this year. So Nike settled its trademark infringement lawsuit against Japanese streetwear brand Baby Nape on Monday, per a joint filing submitted in New York Southern District Court. So they sued them in New York. And again, just to kind of put you guys all on notice, when you sue somebody for intellectual property infringement, for the most part, that's a federal offense. You have to go to federal court. You can't go to the state court within that particular state. You have to go to federal court within that state. So whether it's trademark infringement, patent infringement, copyright infringement, you have to sue in federal court. As a federal court has exclusive jurisdiction of these matters as opposed to state court. So again, that's an important distinction when you're talking about IP infringement. So Nike settled its trademark infringement lawsuit against the Japanese streetwear brand Baby Nape on Monday and filed in New York Southern District Court, which is essentially federal court. The stipulated dismissal says that Baby Nape and Nike entered into a settlement agreement. Most of these cases do enter into a settlement agreement to resolve the battle over Baby Nape's most popular sneakers, many of which are derived from classic Nike styles. That's what you will get a lot of time. And Nike is not playing around. You see a lot of companies, Nike, I'm going to do a lawsuit breakdown live on Sundays at 7 p.m. Eastern time, which I typically do. Some type of companies, infringement lawsuit, IP infringement lawsuit that they're suing. Typically, it's bigger companies suing smaller companies. But Nike, if they don't mess around when it comes to a trademark infringement or patent infringement, but a lot of times trademark infringement against people who are trying to piggyback off their popular shoe, the Air Force Ones, the Jordans, they typically going to hit you with a lawsuit pretty quickly. And typically that ends in a settlement. And that settlement means that, hey, you cannot sell the shoe. Now, I want you guys, another question I want you guys to leave me a comment is, do you think Baby Nape won in this lawsuit based on the settlement agreement, which we'll talk about here later? I kind of think that they won, but I want you guys to let me know if you guys agree with me or disagree with me. So in a statement, what's popular sneaker? Okay, in a statement too complex, Nike said that Baby Nape agreed to discontinue 3 sneakers and modify the designs of 2 sneakers. So the lawsuit has been resolved. Nike said in a statement, Baby Nape did not respond. So it seems like it's been going on since 2009. And the lawsuit seems like was officially brought in 2023, which is crazy that they try to give them 14 years. They seem like they offered them a Nike a licensing deal back in 2009, which is shown here. Baby Nape didn't take it. But these are the shoes. I like the fact that they got a nice chart. So you have the Air Force Ones are here to the left. So these are the Nike's trademark designs, which is they're showing you the trade dress. So with all 5 of these shoes, the elements that are shown in solid lines are the protected portion of the shoe, and the elements that are shown in that dash lines or broken lines is the unclaimed portion. So again, these lines here, these lines here, these lines here, those are all the claim what Nike is claiming protection to in their trade dress a trademark, essentially, trade dress protection with the USPTO. And all the broken lines, they're not claimed. So they can't claim protection to the back of the shoe. Again, they can't claim protection to the tongue of the shoe, which you see here. So a lot of, just again, a physical appearance, most likely that's you see here in solid lines is what they're claiming. And again, I see here the Air Force One mids, the Dunk lows, and then you have the Jordan low and a Jordan high, the Jordan 1. So with the what they were saying before, that the lawsuit or the settlement is saying that Babe and Ape is no longer going to sell the Babe and Ape style mid. So this right here, they're no longer going to sell the court style high, which is right here, and then the court style, or the court style low, which is right here. So these 1, 2, and then let's see, who was that? 3. Those they agreed to discontinue those sales, which again, that's a win for Nike. However, the Bape style, which is here, as well as the Dunk, which is here, the agreement calls for Babe and Ape to modify it. So they can still sell it, but they have to modify it. And as you are looking at, again, for example, if you look at the regulation number 905, which is the top left shoe, and you look at the Bape style, they're essentially the same thing outside of the logo. But again, trade dress is the physical appearance. They don't necessarily care about the logo. It's more so the physical appearance. So just because Babe and Ape doesn't have the Nike logo and instead has this shooting star, if you will, that doesn't get them out of the realm of trademark infringement. The fact that they still have those solid line elements, you see this line right here that's similar to this line. You see the shorter line, curved line that's similar to this curved line. You see this in the front, the line in the front portion is similar to this line in the front portion. You see that kind of sole line there similar to this. So, again, a person is probably be confused, which I would imagine you let me know if you're going to be confused based on looking at the Babe and Ape, the Bape style and seeing, okay, that seems similar to the Air Force Ones, which we all know those Jordan 1s as well as the Air Force Ones, those are 2 of Nike's popular shoes, which is why I think that this is actually a win for Babe and Ape, because again, we know Jordans as well as the Air Force One are staples within that Nike wheelhouse of shoes. And the fact that, okay, Babe and Ape gave up something. We're going to stop selling the Jordans. But it was a modification that they have to do, that they can still sell their Babe. Again, let me bring it back up. The Babe and Ape style, they just have to modify it a little bit. We'll see the modification. You guys let me know if you think that modification was significant or do you think it was insignificant. So these are the shoes here. Again, just to recap, Babe and Ape has agreed to discontinue the style mids, the style high, and the court style, and they're going to modify, but they can still sell the Bape style as well as the skate style, which is similar to the Dunks. So I guess we'll kind of finish off on this portion of the article. The most recognizable Bape shoe, the Bape style, was introduced. So again, that's a win for them. The article is saying the Bape style is their most popular shoe, and as we just read, they can still sell the Bape style with a slight modification. So I think that's a win for Babe and Ape. So it was introduced in the early 2000s as a flashy, more expensive alternative to Nike Air Force One. The first Bape style was virtually the same as the retro Nike shoe. Instead, it had the star logo as opposed to the swoosh. The Nike lawsuit was the latest in a long line of legal action. They were pretty much saying, hey, Nike is coming after people who try to, steal that swoosh silhouette. The conclusion is not a surprising one. I think it is a surprising one. Most of the lawsuits have ended in settlements, which that part of it is true, which usually involve the smaller brands agreeing in some way to modify their designs. At an initial pretrial conference on the 14th of March, a lawyer for Babe and Ape said that they were remarkably close to reaching a settlement. According to Nike, Babe and Ape will change the Bape style and the skate style, which are based on, again, the Air Force Ones and the Dunks. Babe and Ape has changed the look of the style before altering it slightly to make its lines and shapes look more or less like the Air Force One over differentiation or different iterations. Babe and Ape would also, Nike says, stop selling the other models. Okay, so we just talked about that. So again, we are going to go. This was the lawsuit article from Complex that came out at the end of April. Recently, let me pull it up. The IG page where Babe and Ape is, they have some new releases of the Babe stock. I want you guys to let me know whether or not these are very similar to what we just saw, or if they're not similar. So it's still, I mean, one of the things I guess, and these are pretty much, this is the two things. I hate the fact that I can't blow this up a little. Let me see here. Okay, here we go. So these are the two changes that I see. Everything is for the most part the same. The two things that I see is they added the ape here at the bottom right-hand corner, and then their shooting star, it extends out further. Typically, the old shooting star was above this soul line, and it was kind of between these two soul lines, where the new shooting star extends below this soul line and extends above that kind of foremost line that Nike was claiming in the Air Force Ones. So those are essentially the two differentiators. Hey, you have the ape that they introduced, and then the shooting star kind of extends further towards the front. And again, as you look at the comments here, let's read some of the comments. Laugh out loud, nice loophole. Why do y'all insist on effing up this shoe? Again, I'm assuming when they're talking about this shoe, they're talking about the Nike shoe, the Air Force Ones. Lawsuit Force One. So it seems like 2425 Bills thinks that another lawsuit is forthcoming. You guys have to let me know what you think of that. Let's see here. Continue to go down here. What we doing? It seems like Hype Beast Whoop is saying what we doing. I'm not sure what they mean there. Somehow you will still get a lawsuit with these new designs. So it seems like Mr. Da Vinci is thinking that a lawsuit, Nike is still going to sue. And then, let's see, after the lawsuit is crazy. King, what Dave OFC says that after the lawsuit settles, y'all, this crazy. So he thinking that they're still gonna sue here. Nike is still going to sue here. And then what Tweez one says, guess y'all saying F Nike, and I don't blame y'all. So it seems like at least a fair amount of the comments are thinking that it at least still looks like the Air Force Ones and similar to the shoe that they got slapped on the wrist for. I'll tell you, as almost 10-year intellectual property attorney, that given the fact that they're doing this after the settlement agreement, I'm assuming that Nike signed off on this, because I would imagine that whatever was in that settlement agreement, Nike had to approve on their new release. And I'm assuming, again, I may be wrong, but I'm assuming that Nike approved these shoes, which I think is a big win, because typically when Nike sues you and it's a settlement, Nike is saying that you got to stop selling these shoes. Maybe you can kind of sell the rest that you had in your inventory, but you can't make or sell any new shoes. That's typically the settlement agreements that you get from Nike. And the fact that Babe and Ape, those modifications as we just saw with adding the ape and then extending that star logo further towards the front of the shoe, in my opinion, those are very insignificant changes. And I think that that's a win for Babe and Ape. You guys have to let me know in the comments, do you agree or do you disagree? It seems like when you looked on the IG page, a fair amount of fans or consumers or potential consumers or people think that it still looks similar to the old shoe and therefore probably still infringes on Nike's Air Force One trade dress. Some people saying that it doesn't. I think that is very similar, and I think that Babe and Ape came out with a big win, but let me know what you guys think in the comment section. To the extent that you guys like this type of content, please subscribe and hit the like button. I'm trying to bring you guys not only some entertainment stuff of the current events, but I'm also trying to bring to you guys some informative information from a trade IP attorney, in this case, specifically dealing with trade dress. To the extent that you have not necessarily a logo or name like the Nike and the swoosh mark, but if you're trying to protect the physical appearance of a product, in this case, the shoe, you need 4 things. It has to serve as a source identifier, which means that when people look at that product, they have to think of your company. It must be distinctive in a marketplace, which is kind of similar to the source identifier, meaning that, hey, when they look at it, they got to think of, okay, this is your company. So when they look at this Babe and Ape shoe with the star, if they think of, hey, this is a Babe and Ape shoe, that counts for the distinctiveness in a marketplace. Now, enough people have to kind of come to that conclusion for you to be really considered distinctive in a marketplace. But to the extent that, enough people says, oh yeah, that's a Baby Nape shoe when they look at what we just saw. That counts for distinctiveness as it serves as a source identifier, meaning that when people see that kind of physical appearance of the shoe, they think of Baby Nape. I'm not sure they check that prong, as a lot of people still think that that's similar. That's similar to the Air Force Ones, but I'm just kind of going through again. I want to give you guys some value, so I'm going through the 4 prongs. The third one is have to be used in commerce. You can't file for trade dress protection and then just sit on the trade dress. You have to actually be selling it or making use of whatever it is that you're trying to trade dress, the product that you're trying to trade dress, and then it has to be primarily non-functional, which essentially means that it can't be important to the use or the function of the shoe. It's the physical appearance, and it can't be like, you can't try to protect or get trade dress protection on the tongue or on the sole in general. It has to be a non-primary, non-functional item that is not important to the use of the shoe and not important, where in other words, other competitors that are dealing within that field, if they would be prevented from selling that product based on you getting trade dress protection on that particular feature, then it's going to be most likely functional and therefore not protectable. But to the extent that it's non-functional, then you can get trade dress protection on that product or whatever it is that you're looking to get trade dress protection on. Again, let me know whether or not you guys agree that this new Baby Nape shoe is not similar to the Air Force One shoe, or let me know if you like, man, yeah, Baby Nape got away with one. And I think it's deja vu. I think it's very similar. I think definitely Baby Nape. Hey, shout out to their attorneys for making this one work. And again, please subscribe, hit the like button, and I'll see you guys next time. Peace.